Good morning to all the students. Today we are going to discuss a very important topic of section 45 of Indian Evidence Act. Section 45 of Indian Evidence Act relates to expert opinion of the witnesses. As far as section 45 of Indian Evidence Act is concerned, it relates to the expert opinion given by the scientist, by the artist, on the aspect of foreign law or on the aspect of handwriting experts. As far as section 45 of Indian Evidence Act is concerned, it does not specify or it does not say anything about the qualification of the expert. As far as the qualification is concerned, it says only the person who is expert. Any person who has got experience in a particular field, it can be treated as an expert. Similarly, any person who has got the skill, he can also be treated as an expert. Thirdly, the person who is well versed with the subject, he can also be treated as expert in the subject. Now the question relates to the admissibility or the reliability of the said provisions of law when we comes to declare it whether this evidence recorded under section 45 of the Indian Evidence Act, what is the evidentiary value of this witness which is recorded by the honorable courts. And whenever we are going to analyze the section 45, we comes to know that the opinion or the witnesses who are recorded by the courts under section 45, the witness recorded has got no binding value as far as the court is concerned. The court is duty bound to analyze this evidence and it is not binding, meaning thereby the court has to scrutinize, the court has to analyze, and thereafter the court has to accept it or the court has got the power to deny it completely, meaning thereby the court, after recording the evidence under section 45, has got ample powers to know whether this is a truthful witness or this is a witness which is not to be relied upon by the courts. It further says that whenever there is any witness before the court who is expert in a particular subject, then it is possible that when the parties at dispute, both the parties may bring their separate legal experts, separate persons who are expert in their fields. Now, since both the persons are coming and deposing against other, if the evidentiary value of both the persons are to be admitted, then it will create difficulties before the court. Therefore, it lies within the ambit and scope of the court whether to accept it or whether to deny it. As far as the expert witness is concerned, there are possibilities when it will be treated as more reliable and more admissible. This is in the case of when the expert witness comes from the government departments, because in the case of government department, generally it is believed that the person has got no personal interest, he has not taken any amount from any person, therefore he is going to be very neutral towards the court, towards the proceedings of the court, towards the parties which are litigating before the courts. Therefore, as far as the reliability is concerned, naturally when the person or when the expert comes from the government departments, then it has got more admissibility value, more reliability as far as the proceedings of the court are concerned. Otherwise, the court has to accept it or has to deny it as per their own versions. They have to scrutinize it very minutely. Why I am saying it that it has to scrutinize it very minutely? Because in so many cases it may be dependent upon the entire evidence of the experts. The court cannot be considered to be expert in every subject. Therefore, when there are so many fields like art, science, handwriting experts, therefore when the court cannot be considered to be expert in every subject, then the court has to depend upon certain persons who are specialized, who are having particular skill, who are having particular knowledge, who are having particular qualification. Then naturally their opinion will be more binding, more reliable, but ultimately it is the duty of the court, because the courts are empowered to impart justice ultimately to the litigants. Therefore, in such type of cases wherein the expert witnesses are coming from various departments, from various sources, then ultimately it is the duty of the court to analyze it and thereafter to decide the cases as per their own opinions, meaning thereby the expert opinion is not binding upon the courts.